Okay. Hello and welcome to Mackenzie Friend. Today we're going to look at seeking advice, engaging and working with legal representation. Today I'm joined by my special friend Gayle Li, who works as a solicitor at McQiu Lawyers in Chatswood. Say hello, Gayle.
Hello everyone.
Okay, so what we're going to, first thing I think when you need to seek representation is that what sort of matter are you looking for? You know, is it a parenting matter? Is it property? Is it initiating application of case, enforcement, contravention, appeal, whole range of things. So you have to know what you're trying to seek. So also, you know, is there a solicitor already engaged? Are you approaching the solicitor for a second opinion? Or are you changing representation? Or if you've discharged representation and looking for new representation? So I think one of the first questions you want to know when you're looking for a lawyer is what sort of things do you want to look for? I would say perhaps experience in family law. Perhaps you might be recommended by another person. You might meet with a lawyer and you have confidence with their advice. A lot of lawyers provide, say, a free meeting for maybe half an hour just to discuss your case. And you might feel comfortable with that lawyer and you might decide to engage that lawyer. Also, you know, it's always good sometimes to shop around because family law proceedings are very long. And so, you know, you will be, you know, having a business relationship with that lawyer for a considerable amount of time. So it's someone you need to be able to work with. So you need a working relationship. So also there's a few things we need to talk about is pertains to the solicitor's rules. Now, a solicitor must provide clear and timely advice to assist the client to understand relevant legal issues and to make informed choices about action to be taken during the course of the matter consistent with the terms of engagement. Now that's also an important point is that when you seek to engage a lawyer, you must be very specific about exactly what you're asking that lawyer to do. Like if you go to a lawyer, say about a parenting matter, and then you want to start to deal with parenting, property issues, then that's obviously outside the retainer that you've engaged the lawyer. So you'll have to go to the lawyer and renegotiate the retainer and give instruction to that effect.
If I can just add to that, so this is why it's so important to have in that initial consultation with your solicitor, that you do explain to them the reason why you're there. The solicitor who is experienced in family law matters will also be asking you questions, probing questions to find out, look, is this the only issue that we are really dealing with here, or is there something else that perhaps you yourself may not have considered? So it is not uncommon that although you've come in specifically for one reason, or you know, or even two reasons, the solicitor may actually find that, well, while you're here, perhaps you should also consider thinking about this and this and this. And then you can go away and think about it.
Okay, so importantly, the solicitor must inform the client or the instructing solicitor about alternatives to contested adjudication of a case, which are reasonable and available to the client, unless the solicitor believes on reasonable grounds that the client already has such understanding of those alternatives as submitting the client to make decisions about a client's best interests in relation to litigation. So also what that is saying is that the solicitor should explain to you about alternative dispute resolution processes that may be able to be successful without having to take the matter to court. Because as we know, in particularly family law matters, litigation is very expensive and avoiding court is always the best option if possible.
So if I can just add also to that one, so be open-minded about that. Don't think that the court is the only avenue open to you or available to you. Even if you think that the other side won't agree to mediation or engaging in some other forms of dispute resolution, don't make that decision for them, okay? Give them the opportunity to say yes or no.
See, I think that's the point. Sometimes when the other party is also engaged representation may want to do conciliation. They want to work between each other. They equally, if they're responsible legal practitioners, they want to dispose of the matter without involvement of the court. And sometimes that can be a good thing. All right, so when you first go on to your solicitor and you're saying, look, I'm now happy with the solicitor, I'm happy with their advice, you're going to have a letter of engagement. And this is basically saying to the lawyer that, you know, I seek for you to act on my behalf in this matter. So now that also involves essentially the retainer. So what exactly you're asking the lawyer to do.
But again,
yes, correct.
Just interject here. So what would ordinarily happen is you'd go and see your solicitor, and provided everybody understands what the job is and the task at hand, the solicitor will give you what is called a cost agreement cost disclosure. Now, this they have to provide you under the rules for any legal services that are provided to a client over the value of $750, not including disbursements. Disbursements are things like, counsel fees, court filing fees, subpoena fees. Now, the cost agreement cost disclosure is something that you can negotiate. So don't think that whatever price the solicitor gives you is the one you have to go with. You do have the right to negotiate, but that doesn't necessarily mean the solicitor has to agree with you. Also, don't think that you have to sign this. If you go away with this document and then the next thing the solicitor receives an email from you and you're asking them to do something, or you've gone and put money into trust, if one or both of those things, it would mean that you have now engaged that solicitor to act.
Yes. So just quickly back on that a little bit about, we talk about counsel fees, which is essentially advice from a barrister. Now, there's two forms. There's usually just seeking advice, the solicitor will seek advice from the barrister just on a particular point of law, and also for the point of representation. Now, not every appearance before a court requires a barrister. It depends on exactly the nature of it, like maybe a procedural mention or some sort of procedural matter. A lawyer could take care of that. The actual client may not have to be there. So it's very much, these costs depend on exactly what you're doing and where you are in the court process. Now, importantly, we talk about giving instruction. Now, this is where you actually say to your lawyer exactly what I'm asking you to do. So, as I mentioned earlier, that might be property, it might be parenting, it might be about writing to the other side, it may be putting an offer forward, it may be drafting an affidavit, or drafting the parenting or property orders, something like that. So it's important that you could provide to your lawyer exactly what you're asking them to do. Okay. Is that okay? We're okay?
Yeah,
all right. All right. Next thing I'm going to talk about a little bit is that once you've engaged a lawyer, now the lawyer has to advise the court. So this is particularly about family law matters. They have to notify the court that they have the authority to act. So they tell the court they have a notice to act. They also tell the other side that they're also acting on behalf of their client, and the other side will likewise advise that they have the notice to act. See, what you don't want to do is to have essentially clients talking to each other, because that's why you appoint lawyers, a representation, because it can get very confusing when you're getting differential instructions from clients talking to each other or trying to talk directly to the other party's legal representation. It gets very confusing. So the point of engaging legal representation is for them to put your point across to the court or to the other party. Okay. Also, it's important because when you don't want to make there is an issue of confidentiality that goes on with these sort of discussions, and you don't want to prejudice proceedings by something that you directly communicate to the other side being evidenced, and would be admissible because it doesn't fall under the exclusions for admissibility under confidential information. So just saying. Also, just another point on confidentiality, which I think is important to discuss. Things like negotiations and mediation, outcomes, even offers, they cannot be evidenced in court. So you can't say, oh, the other party agreed to this particular arrangement, therefore I want to see it's binding. These are just part of the negotiation process. They're not binding. So it's just important to talk about that. Now, when a solicitor ceases to act, they have to, and that may come about, we'll discuss that later, over a range of issues, but they also have to notify the court and the other side that they no longer acting in the matter. Now, here's another thing. We're going to talk about lien over documents. Now, normally when you engage a solicitor, you have to put money into trust, because, which means they can draw upon that money in all payment of fees, such as filing fees and disbursements and all those other things, and their costs. Because it's very common in most legal matters that clients don't pay, especially if they don't get the outcome they want. So what happens is that you do terminate agreement with a lawyer, and you have unpaid legal fees. They hold a lien, or they can withhold your documents until such time as you've settled that account.
Provided it doesn't prejudice the matter.
Yes.
So what can sometimes happen is the solicitors, let's say you then engaged another solicitor firm, and but you still had outstanding fees to the first solicitor. So that first solicitor can, as Cam was saying, can hold those documents. They can hold a lien over those documents, which basically means unless you pay out, I get to keep these documents until that happens. But if the solicitor for the other side provides an undertaking that your fees will be paid at the conclusion, then the solicitor who's holding your documents may agree to release them. But generally speaking, as a solicitor, we don't give undertakings because unless we ourselves can control that. Now, if I had a client who says, well, you promise them that I'll pay, I won't agree to that. It's like, no, just go and pay, all right? But then again, if the other solicitor had some document that was prejudicial to your matter and there was a hearing date in very, very soon, then it would be prudent of them to release at least that information to the solicitor acting. But it can be quite difficult to get agreement on that.
Also, you have to say, like, if a client can't pay their previous solicitor, then the next...
It's a red flag for the current one.
That they may not get paid as well. So, yeah, you might find some reluctance in being able to engage representation if the previous solicitors are still holding a lien over your documents. I was going to say something else about that, but oh yeah, probably the important point, when you're in litigation, make copies of everything that's sent to you from your legal representation, so at least you'll have something in case this happens. Also, we need to talk a little bit about, just because you've engaged a solicitor doesn't mean you can necessarily run off to court immediately. Often in family law proceedings, you are supposed to attempt mediation, and they talk about that 60I certificate, where you have to attempt mediation, and upon that being unsuccessful, you'll receive a certificate, a 60I certificate, and that is a pre-filing requirement to make an issue application. Not all applications before a court require a 60I certificate. So if the matter was urgent, subject to family violence, blah, 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 there's exemptions. Yes, that's right, property. There are exemptions under 60I 9 with the Family Law Act if you want to look at that. But I just thought I'd just mention that in passing as we go along. I've got a bit to get through here. Right, now I'm going to talk importantly about how to reduce your legal costs. So I'm just going to talk about things that you might want to do that may assist in reducing it. I think one of the most important things is to give clear instruction. Like the more that your lawyer has to call you up, go back and forth, write letters and communicate, the more it's going to cost you because you're taking up their time. So you want to be as efficient as possible. So be very clear on what you need to do and also respond in a timely manner. If you're asked for documents, then you get them there as fast as you can. Because remember, often the lawyer has filing dates they must meet as well. Also, if you're given advice, follow it. It's really important that, why seek advice if you're not going to follow it? Like, I'd have to say that most people prejudice their own proceedings. A client is often their worst enemy.
But again, if your solicitor has given you advice and you don't agree with it, then you've got to let them know, and you've got to let them know the reasons. They have to understand the reasons why, okay? Because it may be because there's a misunderstanding. You haven't actually understood the advice. It may be because there is information which the solicitor is not aware of. So the advice they've given you is not the correct advice because there's, as I said, because the information before them in coming to that decision is not complete. It may just be simply because you just don't like it, in which case that's where Cam's saying comes into play, because you're paying this person for their professional opinion. Okay, so if you're not going to respect that or follow that, then why are you there? Why are you paying for it?
Okay. The other thing is about being realistic about the outcome you're seeking. Because let's face it, if you look about what family law litigation is about, it's about getting orders. Everything else is basically in support of the objective. So what you need to do is you want to seek realistic orders that the court is likely to grant and that are going to be practical and effective and the best interest of the child. So you really, so sometimes parents often seek sole parental responsibility, but there's no grounds for that. So as a lawyer, you'd be saying, look, I really think you need to be more realistic about what you're seeking. I don't think it's going to be held up in court. I don't think the evidence supports what you're trying to say. So it's important that your lawyer will actually tell you when you're, let's say, not being reasonable. Okay. Also, I'm going to quickly talk about this. This thing about sense of entitlement. This comes up a lot in family law matters. Now, a parent does not have a right to see his child. It is the child's right to be cared for by their parents. So going in front of the court and just saying, I'm a parent, I have a right to see my child, is not what the principle of the Family Law Act is about. So what you do is you're trying to sell to the court that you should be it's the benefits of the child for you to be in the child's life. And that's what you're trying to do. So coming on and showing a sense of entitlement and just being arrogant and difficult is not going to help your matter. It's probably going to cause consternation between yourself and your legal representation, things like that. Now, it's okay to fight with your legal representation, but don't do it in open court. Like, if you have to, private room, express your concerns in a professional manner, and hopefully you can resolve things out. It's not good when a client and their legal representation are having issues in the presence of the court. It's just not a good thing. All right, some other little things. Cost orders. It is very rare in family law proceedings that a cost order will be sought against the other party. So just because the other party has brought proceedings, family law is particularly party costs, don't expect that you're going to be able to recover your legal costs against the other party. Just put it out there, and that's probably an incentive to try and settle as well, because you have to come to the point where the advantage you think you might be achieving, particularly in property proceedings, is likely to be outweighed by the amount that's going to be essentially destroyed or wasted in legal fees.
Yeah, but even if the court felt there are exceptional circumstances to grant cost orders against another party, the party in who is to benefit from that cost order, you're not going to get everything back, okay? Because under the family law fee structure, it is actually capped. There's certain things which are capped, and so you're never, ever, ever, ever going to get 100% of your money back.
Yeah, so the actual cost agreement you sign with your lawyer is usually in excess of what is in those scheduled fees. I don't think there is a lawyer out there that could operate on those scheduled fees.
Think of it a bit like private health insurance and what a doctor actually or specialist actually charges. The private health insurer is never going to give you back 100%. Same goes for the law. Okay.
Something else I think this is a bit of a mixed one. Is about I think it's good for your case for you to learn as much as you can about family law. Now, a little bit of information can be dangerous, but sort of understanding basic principles, sort of things like the best interest of the child is paramount. The considerations under 60cc that the court used to determine the child's best interests. Issues of family violence. A little bit about how property and how they determine property through the four-step method from Stanford. Like, all learning about that will help you understand what likely outcome it is and what to negotiate, when to stand hard and when to concede.
And where to find these things? Go to AUSTLI. So it's AUSTLI. So just Google AUSTLI and look up the Family Law Act, the Family Law Regulations, the Federal Circuit Court Regulations, and family law rules. This actually this is where you find that information that tells you what the court does, okay, and how they will apply evidence to a particular matter.
Okay. Another thing is it's important to stay confined to the issues in contention. Like, nothing is worse when you've got a client that wants to talk about something that is irrelevant or is just not important to the matter. It wastes a lot of time, wastes a lot of money. You just got to make sure that the court is only interested in dealing with issues in contention.
And that doesn't necessarily mean the issues that you think are in contention, because that's likely to be everything. It's the main issues.
Okay. Next I'm going to say is that your lawyer is not your friend. This is a business agreement. So don't waste money just venting about things. It's about getting the matter sorted, okay? Don't try and emotionally convince your lawyer or see if you can convince them to the merit of your story. Often lawyers have learnt over many, many matters that clients they may lie, they may misrepresent, they may embellish, they may diminish the significance of things, and such that the true story of your matter only usually comes out after maybe the other party has put their evidence on, or there's been a family report, or there's information, independent information. Like, it is not unusual to have a client and then discover magically they've got all these undisclosed, say, protection orders against them. So yeah, it's really unhelpful. I think that's another really important thing. You must be honest with your lawyer. You must tell them all the good bits and the bad bits, because it is nothing worse for a lawyer to stand up in court and find out that your client has a criminal record or something like that. It makes you look very, very stupid, and it can just destroy your case instantaneously. And you're not going to be happy with your lawyer, and they're just going to be throwing their hands up in there. in their heads and going, oh my God, and like how these people are supposed to work for you effectively if you can't even disclose such information to them.
We need to know warts and all, and don't be embarrassed about this, because to be honest with you, our advice is going to be wrong if we don't know everything, and we really mean everything. Okay, it doesn't necessarily mean you bring in, you know, pictures of your ex-partner's, you know, anatomy that he's sending off to his new partner. We don't need to know that stuff, but we do need to know about, like, if as Cam was saying, if you've got a criminal history, if there's been any accusations which are not positive, if you know yourself that you have engaged in behaviour which is less than reputable, we need to know this, because it's likely to come up. So there's no point trying to skirt around it, and we need to be prepared for that.
Okay, just to quickly, a few points on cost orders. Now, this can happen if parties don't file on time or things like that. So it is important to get the information to your lawyer as fast as possible, because there is a possibility the other side may make an order for costs if it delays and prejudice proceedings. So just be mindful. It's not common, but it's really important that when the court wants something, they want it, and they won't wait for anybody. That means you just, you know, you can't decide when you want to turn up to a hearing. You know, the court runs the show. Also, if we talk about property just quickly, there is a duty of full and frank financial disclosure. Now, this starts even before an application has been made before the court, and it continues throughout proceedings. So if circumstances change, you must update, you must give full and frank disclosure, because otherwise you might, the court may set aside the matter later on and put a cost order against you. You know, that's under 79A, failure to disclose, something comes up, you know it. Oh, that was professional, wasn't it? I don't want to get into full and frank disclosure. I hate that property. All right. Now, I think it was important about not making your matter worse. Now, as I said before, that clients are often their own worst enemy, because you're going to be before the court for several years if this is a full matter and it runs all the way to final hearing. So you need to tell your lawyer about family violence, protection orders, criminal history, even mental health. And don't embellish, sanitize, or mislead your lawyer, even though we discussed that. Now, you're in for the long haul on this. This is a long game. So this is not about early point scoring. You have to stay focused on the prize. And the prize is getting orders that you can live with so you can have a meaningful relationship with your child. That's what you're there for, or property.
So the average duration at the moment with court proceedings is 3 years. That's the average. There are some which go a lot longer than that. The ones who tend to settle before 3 years are the ones where the parties have essentially come to their own agreement.
Or run out of money to continue fighting.
Yeah, there's that too. They just continue fighting, but in other ways. So.
Yeah, then they don't apply by their orders. It just is messy. Also, the court will see through any ulterior motive. Like if they think that you're trying to set up the other party to obtain incriminating evidence against them, you know, the court's very sensitive. This is what they do every day. They will see behind behaviour of parties. So you've got to be very careful about this. Also, it's important not to enhance the acrimony. Like if you're before court, then obviously you're not, one or more of you is not being sensible. You know, obviously you can't come to an agreement. So it's important not to make the matter worse, and that means you know, you wouldn't be writing nasty things on Facebook, denigration, telling lie, or just information to friends and family to try and discredit the other party. It's just not worth it. If you need to vent, don't do it in writing or anything like that. Just, you know, take a friend down to the pub over a few beers and just get it out of your system.
No,
don't put it right.
Not even that. Go to your bathroom while you're in the shower that night. That's the moment where you can vent. Okay, when there's no one else around you, that's when you can vent. Yeah,
there are times where friends will stab you in the back. Yeah. There are dads in distress groups and support groups like that, and they have a confidentiality agreement. And usually the first half of those meetings, which are very good to attend, where people just get it out of their system. And as an alternative, I'd recommend that. You know, unless you go into the bathroom and you start fighting with yourself. Don't want to do that.
And just another little quick tip, if you are going to court, if unfortunately you are in that situation and you struggle to perhaps keep your comments to yourself, or even to follow what's going on, take a pen and a pad and go in there and just write down what you're hearing, okay? Because first of all, it focuses your mind on something else. You've got now a task to do, okay? You're less likely to stand up, make a scene of yourself, and potentially damage your own reputation. And then when you get out of the room, you've got the chance to sit down with your lawyer and go, okay, what happened here, or what does this mean, and it just helps with the process.
Often it can be very difficult, especially if the other side is not represented, they're self-represented, or you're self-representing and you're against a legal representation. It's quite a difficult and technical process. You need to be very mindful and certainly even attending a few hearings if you want to be a self-represented litigant, to sort of understand the court process and how to behave. Now, just being child-focused, if you did nothing else, dressing well and being child-focused will greatly enhance your prospects and outcome.
Being respectful to the court and respectful to the other party, whether they've got representation or not, that will also be good for your own reputation.
I'm going to talk a little bit about illegal and improper conduct, even though that this makes it inadmissible under, I think, 138 of the Evidence Act, about hacking emails and Facebook. So very important. It would be inadmissible if you were to hack the other person's, say, email account and try and use that material in court. Same with also if you denigrate the other person on Facebook, as I've seen often, that these things do end up in affidavits, and it can be quite damaging to you. So again, don't put anything in writing. Also, surveillance and recording. Now, GPS surveillance, I was involved in a matter a little while ago where a person actually hid a GPS tracker inside a child's toy. That didn't go down well, and that actually did do massive amount of damage to the other person's case. Often this is unnecessary. You shouldn't go to that extent. Also, sometimes recording of handovers and things like that, this is a bit more of a grey area. It depends on the state and the Surveillance Devices Act, which is in New South Wales. It is possible to do it for the protection of your own legal interests. Also, if you think there's a possibility of family violence. But then again, if you start to use it outside of those constraints, then it'll probably be inadmissible. And the other thing is that the court does not take well to a parent essentially using a child to gather information on the other parent. So the court will always just take the view of whatever is in the child's best interests. Okay. Now we're going to go on to something a little bit more contentious. We just want to talk a little bit about solicitors' rules. Now, solicitors are actually bound by the solicitors' rules. Now, I'm going to talk about, firstly, it's the paramount duty of the court. In other words, a solicitor's duty to the court and the administration of justice is paramount, prevails to the extent of inconsistency with any other duty, which means that the duty of the court is above their duty to the client. That's important. So a solicitor is not going to do anything that advantages client over diminishing the court. Just also, particularly from Clarkson in 1972, which is the case, this duty to the court is elevated when the best interests of the children are paramount over the interests of a solicitor's client. So they will place the duty, so there's a paramount duty to the court, then there's the duty to the child, and then there's a duty to your client. And these are all essentially concurrent duties, but there is a little bit of a priority. All right, also about the ethical duties of a solicitor. A solicitor must act in the best interest of a client in a manner in which a solicitor represents a client, must be honest and courteous in all dealings in the course of legal practice, deliver legal services competently, diligently, and as promptly and as reasonable as possible, and they must avoid any compromise to their integrity and their professional independence, and complies with the rules and the law, which includes the particular court's rules. Now I'm going to talk a little about frankness in court. Now, a solicitor must follow a client's lawful, proper, and competent instructions. However, a solicitor must not act as a mere mouthpiece for their client and must exercise forensic judgment. Now, what this essentially means is if you give improper instruction to your solicitor to do something and they're not happy with it, they're not in breach of their duty to the court by not following your instructions.
Or even if it's not a case that your instructions are improper, and they may be very proper, but it's just not the right time or the moment to bring that up. So as much as you would like the judge to know that about something, the solicitor would have a better understanding as to whether or not that's the appropriate time to be raising that, or because it may. The other thing is, it's not to say it's not important to you, because obviously it is, but as far as the whole spectrum spectrum goes as to what the issues are in dispute. It may be just a very small, insignificant matter in comparison, and it won't do you any favours by, whinging, essentially.
Okay, I think there's a point, like there are different types of appearances before the court. Like if you take a directions or a mention, these are procedural matters fundamentally. So you're not arguing the merits of your case at that time. So it's important to know exactly what you're before the court to do. So a hearing, that's a little bit more, that's when the court is going to listen to those sort of arguments. But no, it's not important to do those sort of things at certain times. So you've got to know where you are in the process and what you're trying to do. Now, a solicitor must not deceive or knowingly or recklessly mislead the court. Well, I think that's pretty obvious. So don't ask your lawyer to do that.
I'm not going to lie for you.
No. And a solicitor must take all necessary steps to correct any misleading statement made by a solicitor to the court as soon as possible after the solicitor becomes aware that this statement was misleading. All right. Now, another thing about affidavits, just quickly. Now, a solicitor, this is from a case called Myers and Elman, which is in a subject we do called ethics. And a solicitor cannot simply allow a client to make whatever affidavit or documents he thinks fit, nor can escape the responsibility of careful investigation and supervision. A solicitor who is innocently put on the file an affidavit by his client, which subsequently discovers to be false, owes a duty to the court to put the matter right at the earliest moment if he continues to act as solicitor on the record. In other words, just because your solicitor asks you to write something in their how would I put this? You just can't put anything you want in your affidavit. The solicitor must provide careful investigation, and if he thinks it's wrong, he will not basically sign off on it and submit it to the court. So,
yeah, so think of your affidavit. Your affidavit is evidence, so it's about facts. It's not about opinion. It's not about hurt feelings. It's not about conjecture. It's about
submissions.
Facts.
Yeah.
It's
not
dates,
case law.
dates, times, events.
Yeah.
Dates, times, events. That's what it is.
And it should be constrained to that. So don't try and draw a conclusion from those dates, times, and events.
Yeah.
Very important. But that's what your solicitor's there for.
And if you're going to include anything like a conversation, then you put down words to the effect of, conversation, the words themselves. Don't just say, she said this to me. It's like, no, it doesn't. It needs to be more specific than that.
Now the point is, if it is inadmissible, it will be struck out even before it goes into evidence. So you want
to get it right.
Yeah.
You really do want to get your affidavit evidence right.
Now, there's probably a point to be made about this. It's like, I'd have to say the initial application and the first affidavit and seeking the orders before the court at the start, it's important to get that right. So you might want to seek legal representation for even just that simple part of the legal process, or you might want to just have a lawyer review it for a fixed fee. But I just think it's really important at the first time that you go before the court is that you've got a good affidavit, a nice chronology, which is optional but very helpful, and a good affidavit that spells out exactly what's going on. And it's just, you can just modify that as more facts go out throughout the proceeding. So I just think it's important to get it right early on, and that's when it's valuable to have a solicitor. All right, just quickly on dishonest and disreputable conduct by solicitors. A solicitor must not engage in conduct in a course of practice or otherwise which demonstrate the solicitor is not a fit and proper person to practice law, or which is likely to materially, to a degree, prejudice or diminish the public confidence in the administration of justice and bring the profession into repute. Look, most lawyers act ethically. There are some where
the majority of lawyers are actually okay. Unfortunately, though, there are some within the profession which, they haven't done themselves or the profession any great service. But look, it really comes down to, I think, communication in more cases than not, and respect. So if you don't feel like you're being respected, if you don't feel like you're being heard, make sure you put things in writing, communicate this to the solicitor. The solicitor will have the right to terminate the retainer with you if they feel as though you've lost confidence in them. But don't be afraid of that, because at the end of the day, this is obviously a very important thing, and you need to be able to work with this person who is meant to be representing you and helping you. And if you're battling with them as well as battling with the other side, it's not going to be a pleasant experience. It's not going to be pleasant anyway, but it's going to be made far worse for you.
Okay, here's probably a tip. Like, if you think about engaging representation, you might want to see them before the court on, say, maybe a shortlist matter, because then you will see if the judge gives them respect. Now, often I'm watching shortlist matters, and you'll see that one legal representation. One lawyer will come before the court, and the judge will just give them a horrendous time because they know most of these lawyers, and that's probably a big red flag that that judge or most judges are unlikely to be favourable to that particular lawyer, and obviously going to be towards that client. Look, it could be the client's fault, but it also might be that the lawyer doesn't have respect before the court.
So you just be mindful though when you are doing that. So certainly it's more a case of seeing how they present, seeing how organised they are, because even if they're getting a bit of backlash from the judge, it may be because their client hasn't been abiding by the orders, their client has been belligerent and delinquent, and but because the judge isn't talking to them, they're talking to the solicitor. So they may be berating the solicitor and saying how things aren't being done properly, yada yada yada. But really, because behind the scenes, there's all this other garbage that's been going on, which the solicitor's not going to turn around and say, oh well, my client won't do this even though I've said that to them. They're going to say things like, unfortunately, we haven't received instructions yet, or that's usually what would happen. Something like that.
There's a bit of a language that goes on in court that isn't necessarily obvious. Words have different meanings, and you can sort of get a sense for it. But as a layperson, you may not be sensitive to this.
But a decent lawyer is not going to risk their reputation.
No,
okay, so
they've been burnt enough times.
If they're constantly being berated by the judge because of matters that are essentially outside their control,
that's fair enough.
Yeah, as a solicitor, I would not continue with you. I would no. Yeah. Sorry.
All right, but now we're going to talk about delinquent clients. Like I've spoken a little bit about maybe delinquent lawyers, but I think it's fair that we talk about delinquent clients because as you can see,
it goes both ways.
It goes a bit way. All right. Now, if a client has lied in a material matter to the court, or has procured another person to lie or to the court, or has falsified or procured another person to falsify in any way document which has been tendered, or has suppressed or procured another person to suppress material evidence upon a topic where there was a positive duty to make disclosure to the court, the lawyer must refuse to take any further part in the case unless the client authorises this to inform the court. Right. Back to that duty of doing it, but you can a lawyer will dump a client if they're delinquent. That's just part out of the solicitor's rules. Now, I'm going to talk a little bit about what happens if a client decides to intend to disobey a court order. Now, the lawyer must advise the client against that course and warn the client of its dangers. They must not advise the client how to carry out or conceal that course, and not inform the court or the opponent of the client's intention. Forget that last part. It wasn't really important. You get the point. Okay. No, we're not. No. I think I've still got one more page. I do. Now, sorry, last thing. Sorry, I'm a little unprepared. I got my notes mucked up. This is a long one. It's hard to sort of keep my brain. Right, okay. Just quick thing about duty to third parties. Now, third parties have rights. A lawyer must respect the rights of a third party. So if a third party's rights or interests are to be affected, that party should be notified and given the opportunity to join proceedings. So, you can't engage in legal proceedings that would diminish someone who is denied procedural fairness to that effect. Okay, that can sometimes happen in property matters. Right, now, we're going to talk about completion or termination of engagement. Now, the termination of engagement will occur when the matter is finalised and everything's done. Now, you can just agree with your client. The lawyer and the client can agree to disengage the engagement, or that the law practice may just decide to discharge the engagement on reasonable notice.
So to summarise,
yes.
Either the retainer comes to an end because the matter ends, because you fired your solicitor, or your solicitor's fired you.
Yes.
Okay.
Or an action of law, which I haven't really got into. Look, I haven't really got into the specific. Yeah. It's a bit more, but it's not for the purpose of this. All right.
They're the three most common reasons.
All right. Last topic, which I think is also an important topic, is how to spot a good or a bad lawyer. Now, we spoke a little bit about how their conduct and their respect before the court, but I'm thinking a I think a good lawyer is one that tries to keep you out of court. You know, they look at alternative dispute resolution options, you know, mediation, even arbitration. They're willing to work cooperatively with the other lawyer. They're not in an eager rush to go to court or overly aggressive or threatening in their correspondence. You know,
at least they're measured. They're measured in their correspondence.
Yeah. Sometimes correspondence is an interesting. Often a layperson reads it and it looks overly threatening, but it's just nature of how lawyers communicate with each other. You don't take it personal.
Or if you aren't represented and you receive a letter from the lawyer, don't think it's not uncommon to be to cause offence. So it's not intended to be that way. Not when I write my letters. It's more, you know, if I'm telling you you have to give full and frank disclosure, okay, then often the natural reaction from the other side would be, I don't have to tell you anything. Why should I tell you anything? Well, it's not because I'm saying you have to, it's because the law is saying you have to. And my client also has to do the same thing, give you full and frank disclosure. So what's good for the goose is good for the gander. Yes.
Now, a lawyer can't give legal advice to the other party, but they must behave professionally within the procedure and advice to that effect, but not legal advice. So, all right, just quickly about correspondence, which we just briefly mentioned. I think a bad lawyer is someone who continues to write letters to the other side when resolution is unlikely, because remember, the lawyers get paid essentially by the word. So if a solicitor writes a letter that is overly wordy than necessary, I think that's an indicator that well, they're over-servicing, overcharging, or just, I don't know, it's just not a good look. Also, I think it's important that a lawyer stops you putting inadmissible material. That means material that's unnecessary, argumentative, scandalous, hearsay, illegal, legally privileged, unfairly prejudicial, misleading, confusing, or unreasonably burdens proceedings. Okay, I think I've finished. Anything to add there, Gayle?
Good luck.
Okay. All right, I hope this helps.
Yeah, I hope it helps.
All right, see if I can stop